You're ready to go. Thank you.
Great. Thank you. Good morning and welcome to this meeting of the Court Reporters Board. My name is Denise Tugade. I am our chair. I have a few housekeeping matters to share before I call the meeting to order, beginning with a reminder to everyone that this meeting is being recorded and accessible via WebEx. Today's meeting will be run in accordance with the Open Meeting Act as required by law. I would ask all of us to please turn our cell phones to silent. You may notice board members accessing their laptops, phones, or other devices during the meeting. They are using the devices solely to access the board meeting materials that are in electronic format. The board welcomes public comment on any item on the agenda, and it is the board's intent to ask for public comment prior to the board taking action on any agenda item. If for some reason I forget to ask for public comment on an agenda item and you wish to speak on that item, please raise your hand and you will be recognized. To better assist the board in accurately transcribing the minutes of the meeting, members of the public who make a comment may be asked to disclose their name and association. However, disclosure of that information is not required by law and is purely voluntary. I want to remind all speakers to please stay on topic and keep your comments to 3 minutes or less. If you agree with a prior speaker, please do not repeat the comments, but rather state that you agree with the comments already made. Moderator, would you please explain the WebEx public comment procedure?
Thank you. When public comment is opened, we will announce that and show a slide on the screen. You will be able to look at the bottom of your WebEx screen to find the hand icon and click that to raise your hand. If you are on a mobile device, the hand icon might be behind the 3-dot other options screen. And if you are a call-in user, you may press *3 to raise your hand. Each speaker will be given 3 minutes with a 30-second warning. We ask that you stay on topic. We will do our best to call on people in the order in which their hand was raised. Thank you.
Thank you, moderator. With that, Ms. Bruning, would you call the roll?
Yes, thank you, Ms. Tugade. Ms. Sunkis.
Here.
Thank you, Ms. Brewer. Here. Thank you, Mr. Dodgenam.
Here.
Thank you, Mr. Manayan.
Here.
Thank you, Ms. Tugade.
Here.
Quorum reached.
Thank you. So we will begin with agenda item 1, public comment for items not on the agenda. Before we invite speakers to begin, I would ask individuals making comments to not discuss pending complaints, pending applications, or pending disciplinary actions that may come before the board for a decision. Such discussions are considered ex parte communications as they could provide information to the board members that is outside of the record, which is in violation of the Administrative Procedures Act. Therefore, such discussions could create a conflict and lead to a board decision being challenged in Superior Court. The board can receive comments regarding the board's processes in general, but it cannot receive comments on specific case circumstances where the decision is still pending. Board staff is available to speak with you about any pending matter. In addition, the board would ask that the public address the board as a whole and not individual board members. Please be aware that public comment during this agenda item should provide information to the board members and is not a discussion between board members and the public. The only action board members can take is to listen to comments and decide whether they want a future agenda item on the topic. No other action can be taken on these items at this meeting. So this may seem at times like the board members are not being responsive. Following these guidelines is critical to ensure the rules of the Open Meeting Act are followed to avoid compromising the speaker's goals or the board's mission. With that, is there anyone wishing to offer public comment? We'll start with folks in person and then we'll go to WebEx. Okay, seeing none in the room, moderator, could you open up public comment in WebEx?
Certainly. If anyone would like to make a comment for an item that is not already on the agenda, you may click the hand icon to raise your hand. We are putting instructions on the screen, and our audio only Calling users can press *3 to raise their hands. We ask that people stick with 3-minute time limit, and we will give a 30-second warning. Our first request for comment is from Ana Fatima Costa. I'm going to send you a request to unmute your microphone. You're unmuted. Go ahead.
You all hear me?
Yes.
Thank you. I am Ana Fatima Costa, a retired CSR and RPR and teacher at West Valley College of Court Reporting and Captioning. My request is regarding the ProctorU request by one of my former students, asking the board if they will consider using the same method of online testing that the National Court Reporters Association uses due to the many difficult experiences of CSR candidates with ProctorU proctors. I notice it's not on the agenda. Given what's happened at the bar exam in California recently and subsequent state bar lawsuit against ProctorU, which is now called Measure Learning. Do you have an update on when that will be on the agenda?
Should we take all?
And is that the conclusion of your comment, Ms. Costa?
Yes, thank you.
Thank you very much. And I do not see any further requests for comment. Shall I close the public comment feature?
Yes, thank you, moderator.
You're welcome.
And thank you to our commenter. We will take that under advisement. And as always, you're welcome to reach out to the board staff. That issue. With that, we will move to agenda item 2, approval of the meeting minutes. That is from November 15, 2024. Are there any additions or corrections to the minutes from the board members?
I have some. Thank you. Under item 13, expedited fees for deposition transcripts, the third paragraph, I have two. The third paragraph, second sentence, should read, maintain position previously taken by board and clarify by regulation or legislation. And add in at the end of that sentence, add in comma, in which case the board will update its website with the revised position. So that was a quote that I had made during the meeting. Those were, oh, and I believe, and there's one other correction.
Just to clarify, that was page 12 of 16?
Yes, and I'm sorry. Yes, absolutely, 12 of 16, 18 of the board book.
Thank you.
And then the middle of the paragraph, the sentence, intent of the law, was not to limit expedite fees. I'm looking for the sentence. I didn't mark it. I apologize.
Is that page 18 as well?
Same page, same paragraph, correct. So I'm not even sure what sentence that is. Let's see. She shared that she contacted the person who sponsored the language, who indicated the legislative intent of the law was, and it says was to limit, it should say was not to limit expedite fees. Those were the two corrections.
Thank you.
Yes, Ms. Brewer.
So I have just a couple 3 or 4 handful of corrections. On page 13, 7 of 16. 2, 3, 4, 5, 6. 7th paragraph, last line. The paragraph that starts with Stephanie Leslie. The last line is just missing a word. It should say that the only change has been effective at the beginning of the year. So it would be to add the word at. And then on page, sorry, these are pretty picky. Page 18, 12 of 16, the 4th paragraph, Ms. Leslie requested ED that. Oh, and that's really picky, sorry about that. And the second to the last paragraph on that page, the second line, parties at the same time. Page 20. Third from the last paragraph, first line. Ms. Gonzalez reported that generative AI takes everything that it has learned before. And then the last line of that page, page 20, in the center of that line, all together, those 2 words should actually be one word, ALTOGETHER, all together. And I think that's all I have.
Thank you.
Great. Thank you, Ms. Brewer. Any additional comments or edits from the board to the meeting minutes? Seeing none, may I have a motion to approve these as amended?
I move that
Yes.
they're approved as amended.
Thank you, Ms. Sunke. Do we have a
I'll second that.
second?
Second.
Thank you, Ms. Brewer. With that, is there anyone from the public who wishes to comment on the minutes? We'll start in the room. Seeing none, we'll go to WebEx.
Is the moderator. If anyone would like to make a comment on the minutes as distributed or amended, you may look for the hand icon and click that to raise your hand. Each speaker will have 3 minutes with a 30-second warning. Are there any comments on the minutes? We do have one comment from Dolores Renee Wood. If you, I'm going to send you a request to unmute your microphone. You're unmuted. Go ahead.
Okay, the only thing that I saw was 10. It says 4 of 16 under number 6, Sunset Review. On the second line, it says which was chaptered on September 25th, 2025. That's what I was going to comment on, the date.
Thank you. I received that. Thank you.
Okay, thank you.
And I do not see any further requests for comment. Shall I close the public comment feature?
Thank you, moderator.
You're welcome.
With that, Ms. Bruning, would you please call the roll to vote on this? Actually, do we need another motion to take that? Okay. Ms. Bruning, would you please call the roll to vote on this item?
Thank you, Ms. Brewer.
Aye.
Thank you, Mr. Dodgenam.
Aye.
Thank you, Mr. Benayan.
Aye.
Thank you, Ms. Sunke.
Aye.
Thank you, Mr. Gade.
Aye.
Thank you. Motion carries.
Thank you, Ms. Bruning. Moving to our next agenda item, Item 3, Department of Consumer Affairs update. I would like to welcome Leslie Barmby of the Department of Consumer Affairs Bureau and Board Relations, who will be presenting the board with an update.
Leslie, you should be able to unmute yourself.
It's already muted.
Thank
Good
you.
morning, everyone. My name is Leslie Barmby. I'm from the Department of Consumer Affairs. Thank you for the opportunity to join you today. In January, Governor Newsom released his proposed 2025-26 state budget, which included a proposal to split DCA's oversight agency, the Business Consumer Services and Housing Agency, into two agencies, the California Housing and Homelessness Agency and the Business and Consumer Services Agency. The proposed California Housing and Homelessness Agency will oversee housing and homelessness solutions and safeguard civil rights. The new Business and Consumer Services Agency will be responsible for consumer affairs, licensing, and enforcement. The Department of Consumer Affairs would be among the 8 departments in this new agency. As part of the process in state government, on April 4th, the governor's reorganization plan was delivered to the nonpartisan Little Hoover Commission for review. The submission of the plan to the commission began an approximate 90-day formal review process. The commission held public hearings on April 23rd and 24th to receive testimony and for interested parties to provide input on the proposed reorganization. Our agency secretary, DCA Director Kirschmeyer, and other impacted department leaders testified in support of the governor's plan and responded to questions from the commissioners. The commission is in the process of writing a report that it will submit to the governor and the legislature. The commission's report will offer a recommendation to the governor and the legislature as to whether it believes the reorganization plan should go into effect. The commission sometimes offers recommendations for how the plan could be strengthened, either through administrative actions or subsequent legislation. The legislature will then have 60 days to review and consider the reorganization plan. The governor's plan becomes effective on the 61st day after it has been given to the legislature, unless either the Senate or Assembly adopts by majority vote a resolution to reject the plan. If approved, the Business and Consumer Services Agency will be created in July 2025 with 1 year of transition and will become operative on July 1st, 2026. In addition to several virtual briefings hosted by Agency Secretary Moss, there is detailed information on the reorganization plan on the Business Consumer Services and Housing Agency website. We believe this is an extraordinary opportunity for DCA to better align with other consumer protection departments. A secretary within the governor's cabinet focused solely on consumer protection will only strengthen our mission, momentum, and delivery of services to California. DCA will continue to keep board and bureau leadership updated on the progress of the governor's reorganization plan. Next, on March 3rd, 2025, Governor Newsom issued an executive order requiring all state agencies and departments to update their hybrid telework policies for employees and increase from 2 to 4 days in office per week beginning on July 1st, 2025. On March 13th, 2025, the California Department of Human Resources issued guidance on implementation of the executive order. The guidance provides defined parameters for which agencies and departments can make case-by-case exceptions to the 4-day in-office minimum requirement. DCA has been working closely with a few programs on identifying additional space needed for this transition. DCA has been hosting biweekly meetings with board and bureau leadership to provide updates and respond to questions. We recognize that this transition will likely require adjustments for many employees, and we are working together to minimize the impacts. We will, of course, continue to keep leadership updated on any additional direction received from CalHR. Let's see. New Compliance and Equity Officer. On April 28th, Levi Hull began serving as DCA's new Compliance and Equity Officer. In this position, he's responsible for leading and coordinating department-wide quality improvement efforts to ensure consistency and regulatory compliance. This position oversees DCA's solid planning and training services, the Organizational Improvement Office, the Equal Employment Opportunity Office, and the Internal Audit Office, and serves as the liaison to the department's Diversity, Equity, and Inclusion Steering Committee. As the department's equity officer, this position is dedicated to enhancing the diversity, equity, inclusion, and acceptability policies, trainings, and activities throughout the department's programs. Levi brings more than 12 years of experience in leading multidisciplinary teams and driving strategic program development. With more than 9 years of experience in EEO compliance and program management, including nearly 3 years at DCA, he is an experienced leader with a deep commitment to fostering inclusive, equitable, and accessible work environments. Finally, each year during the first week in May, we celebrate Public Service Recognition Week. I want to close with a special thank you to the board, your executive officer, and board staff for your hard work and dedicated efforts to achieve our mission of consumer protection. We are grateful for your partnership and applaud your extraordinary service each and every day. Thank you again for the opportunity to be here today, and I am happy to answer any questions you may have.
Ms. Barmby. Seeing no further questions, appreciate your time here.
Thank you.
With that, we will move to agenda. Board comments, seeing none in the room. Do we have any on WebEx?
This is the moderator,
Seeing
and
none.
if anyone would like to make a comment on any of the DCA updates, you may click the hand icon in order to raise your hand. Our call-in users can press *3 to raise their hand. Are there any comments on the DCA update? I do not see any requests for comment. Shall I close that feature?
Yes, please. Thank you, moderator.
You're welcome.
Okay, we will move to agenda item 4, report of the executive officer. I will turn it over to Ms. Fenner.
Thank you, Chair Tugani. I will start off my report with a review of the budget, as usual. If you look on page 25 of the board meeting materials, you'll see the expenditure projections for fiscal month 8 of the current fiscal year, 2024-25. You see we are really close to our bottom line, so we are closely watching expenditures, hoping to keep the budget positive. Does anyone have any questions on the expenditure projection report? I don't see any. Okay, moving on to page 26, you'll see the overall fund condition. And you can see that we have adjusted the projected transfer to the TRF beginning the next fiscal year, which is 25-26, to $150,000 per year. As you know,
Mr. Minaya needs to appear on camera. I'll text you.
there was a question?
Mr. Minaya needs to appear on camera, so Ms. Fleming said she will let him know.
Sorry. I was saying that it's a difficult item for us to budget for because we never really know how many claims that we will receive in any given year. On the fund condition, if you go down to the months in reserve, you can see that the budget year 27-28, we are now at 6.4 months in reserve. So we are close to the 6 months
operating reserve that we need in order to fund the TRF. So we will continue to keep a close watch on the future projections in order to alert the board to the need for a possible future increase. Are there any questions on the fund condition? Ms. Brenner? Being none, I will turn it over to Ms. Bruning to update you on the transcript reimbursement fund.
Thank you, Ms. Benner. For the current 2024-25 fiscal year, the TRF has paid out more than $55,000 for pro bono cases. We have, I apologize, let me grab my more recent notes. So for pro bono cases, I apologize, we've paid out over $87,000 for the fiscal year for pro bonos. And for pro pers, we've paid out over $48,000 in the fiscal year. We have over $60,000 in pending invoices. We currently have 11 pending pro bono cases awaiting review and 23 pro per cases awaiting review. Any questions from the board? Thank you for your consideration.
Thank you, Ms. Bruning and Ms. Green, for all of your hard work on the TRF program. Moving on to the enforcement statistics, you can see the report for the final report for fiscal year 23-24 on pages 28 to 32. And the following pages 32 to 35 are the stats for July 1 through March 31 of 2025, July 1 of last year through March 31 of this year. Does anyone have any questions on the enforcement statistics? Being none, moving on to the results for our license exam. They begin on page 33 of the board agenda packet with the comparison of the steno and the voice writer skills portion of the exam, followed by the historical results of the overall exam. I do have some results to share from our most recent exam in March. They just went out, so they weren't finalized in time for the board book, but we had 105 people take the skills exam, of which 42 were voice writers. Out of the 105 applicants, 43 were first-timers, and of those 43 first-timers, 31 were voice writers. This was also the first skills test with the new pass rate of 95% accuracy. And we had a first-time pass rate of 83.7% with 57.1% overall. If we separate out the voice writers, the first-time pass rate was 90%, and the overall pass rate for voice writers was 87.5%. For the steno writers, the first-time pass rate was 69.2%, and the overall was 38.5%. Since January 1st of 2025, we've licensed 72 court reporters through the NVRA reciprocity on the skills. And we have a total of 219 licensed voice writers right now. Do we have any questions on the results of the exam? Continuing after that, we have the results for the written portions of the exam, the English and the professional practice, and they appear on pages 36 through 39. As an update on the skills format, we are still working with staff at the Senate Business Professions and Economic Development Committee on language for changing the skills format from 4-voice to the national format. We know that the schools are going to need some lead time to change their curriculum, which is never easy or quick. So we're also working with real-time coach, and our database developers to explore the option of allowing candidates to choose whether they want to do a 4-4 exam or the national format. Obviously, they would have to commit to one or the other for that test cycle, but hoping that that will give some transition time, ease the transition pain as we make that change. I want to give a great shout out and thanks to Laura Brewer and Robin Sunkeys. They headed up a test writing task force, and thanks to all of their hard work, and it is definitely hard work, we have a test bank ready for pre-testing and recording whenever we have the legislative authority to move forward. Are there any questions on that portion? If not, moving on from the exam, the next portion of my report is concerning victims of the Los Angeles fires. And it was such a devastating time, and it continues on for thousands of people. I just want victims to know that there are resources that can be found, and there's a website that the governor has set up. It's www.ca.gov/LA fires. One of the resources I also wanted to point out, one of the executive orders that Governor Newsom issued allows licensees in affected zip codes to defer payment of their license renewal fees for 1 year. And I would just close with, our thoughts are definitely with those that are involved with the rebuilding effort. This is such a huge effort, such a devastating loss. The next item on my report deals with an update. I don't know how many are familiar with this case. It's a California Supreme Court case called Family Violence Appellate Project versus Superior Courts of California. If anybody wants to track, the case number is S like Sam 288176. The case presents the following issue. Does the prohibition on electronic recording of certain proceedings in Government Code Section 69957, Subdivision A, violate the California Constitution when an official reporter is unavailable and a litigant cannot afford to pay a private court reporter? So in its February 19th order, the Supreme Court ordered respondents and the legislature to show cause why the relief sought in the petition should not be granted. In essence, respondents must, and the legislature can, issue a response as to why the relief sought by the plaintiffs, which is essentially a mass expansion of electronic recording in proceedings in court, are at odds with long-standing law, why that should not be granted by the Superior Court. So they are taking briefs, amicus briefs right now. I don't know what the deadline is on that, but because the board has a history of opposing large-scale expansion of electronic recording as not being in the best interest of the consumer, I helped Scott Cronlin's office, who is an attorney, filing an amicus brief on behalf of SEIU and a number of court reporting associations, including the California Court Reporters Association, to provide numbers on the increase of the numbers of applicants to the exam and the increase in the number of voice writing licenses being issued. We will continue to follow the case, as it definitely will have lasting effects for California litigants. Does anyone have any questions? Okay, and the final portion of my report is an update on our technology modernization project. Hard to believe, but July will mark the 1-year point for our new database. I can report that we're saving a great deal of staff time by not having to manually process and file the paper renewals. This has allowed us to promote our office technician to a staff services analyst who's now working on processing TRF claims rather than opening mail, which used to be largely renewals. I'd also like to congratulate Kim Kale, our licensing analyst, for being awarded a gold level Superior Accomplishment Award for her outstanding work on the technology modernization project. While the entire staff had their fair share to do to get us up and running, her commitment to the project from the inception to the completion truly has been outstanding. So congratulations, Kim. Do we have any questions on the technology modernization portion of my report? In that case, if there's no other questions, that concludes my report, Madam Chair.
Thank you, Ms. Fenner. With that, seeing no comments from the board, are there public comments in the room? Okay, seeing none. We'll go to WebEx, please.
If anyone would like to make a comment on the executive officer's report, you may look for the hand icon, typically at the bottom of your WebEx screen, or if you're on a mobile device, it may be behind the 3-dot other options, and our call-in users may press *3 to raise their hand. Each speaker will have 3 minutes with a 30-second warning. We do have a request from Mary Pierce. Mary, I'm going to send you a request to unmute. And Mary, you should have seen a pop-up on your screen, and you can choose the left-hand option, unmute me. There you go, you're unmuted.
Okay, yeah, boy, that was quite a delay to get that. Just I wasn't ignoring anybody. Mary Pierce, I'm the legislative chair for CalDRA, and thank you for your report. Yvonne, I just wanted to add on the Superior Court, Supreme Court case that Stephanie Leslie, as president of CalDRA, also filed a declaration with the court on that matter. Thank you.
And I do not see any further requests for comment. Oh, let's see, I do have one more. And this is from Ana Fatima Costa. I will send you a request to unmute your microphone. You're unmuted, go ahead.
Thank you, Yvonne, for your very enlightening report, and 95% pass rate is something to celebrate. I also appreciate the new website. I teach all of my students how to not only access and be informed of board activities by subscribing to the email notifications, but also we go through how to use both of the websites, the public website and the private CSR only website. So thank you and your team for these wonderful resources.
And thank you for your comment. I do not see any further requests for comment. Shall I close that feature?
Thank you, moderator.
You're welcome.
With that, we will go to agenda item 5, legislation, and I will turn it back to Ms. Fenner again.
Thank you, Chair Tugade. On page 40 of the board meeting materials, you'll find the list of bills that we're following for the current legislative session. First bill is AB 479 from Assemblyperson Tanepa. This one deals with notifying a board if a court is vacating a conviction against a licensee. Does the board wish to discuss this and or take a position? I'm seeing no appetite for that one. Okay. The second bill is AB 711 from Assemblyperson Chen. This bill would require notice to other parties if one side is hiring a court reporter. I believe it's intended to help with the situation where multiple court reporters are showing up for the same proceeding, which is a strain on the court reporting resources. Does the board wish to take a position or discuss this bill? Yes, Ms. Wu.
I am strongly in support of this because it really impacts the shortage of reporters covering court cases, which is the most dire, or seems to be the most dire, and I'd be in favor of taking a position of support.
Ms. Sunkees?
Yeah, I agree with that the board should take a position in support. And I would say that without this, there's the appearance of a shortage because you've got multiple people showing up for one hearing and unavailable for other hearings that they could be working on. So I think this is a good bill.
I will add, I too agree with this way of addressing what is, an artificial shortage in some ways in the court. I do have some questions about what enforcement looks like. It doesn't seem like there's some additional, enforcement measures to the bill, but agree with the goal of it.
And perhaps Ms. Pierce from DRA, who is sponsoring this bill, might be able to help with that.
We'll see if are there any other comments from the board? Mr. Manayan?
Do we know what the noticing requirements will be, or will it be onerous on parties, or is it just a simple, I don't want to say garden variety notice? This is probably a question for staff. I'm not sure if we have that now or if that's something we can look into.
As Ms. Sunkees mentioned, I know we have representatives from DRA on the meeting, and so perhaps if there are no further comments from the board, we can turn to public comment. We have someone in the room.
Good morning. My name is Michelle Caldwell. I'm the president of the California Court Reporters Association. We co-sponsored this bill. There is I think the last iteration was a 5-day requirement for notice. We agree with the position that this will aid in the perception of a shortage. I've personally been in hearings where there are as many as 6 reporters for a 1-hour calendar, and each is 10 minutes long, or parties are booking multiple reporters at the same time, which is really just lending itself to the problem of the perception of a shortage. So we hope that the board chooses to support this. Thank you.
Thank you. Yes, please.
I guess to up on that, I'm Diane Freeman, and I'm representing the Deposition Reporters Association in California today. And the only thing, we are definitely in support, obviously, we sponsored it. And it did say in the bill that the moving party has to notify the court. And just on the top of my head, I don't know this, but I was thinking that it would be up to the judge to enforce it. But that's my opinion. Thank you.
Yes. Turning to WebEx for additional public comments.
Thank you. This is the moderator. If you'd like to make a comment on this issue, you may look for the hand icon and click that to raise your hand. We do have a request from Mary Pierce. Mary, I'm sending you that request to unmute your microphone.
Hello again. I'll make a couple quick comments, and then if you have any additional questions, I am reasonably knowledgeable about this bill. I am not aware that there is anything in the bill that addresses actual enforcement, but most of you probably know that the attorneys are already required to have a meet and confer, but it just seems, well, I hate to be abrasive, but it seems a little ridiculous that they don't ever talk about this. And the duplication is such a waste of human resources and client money, because when 3 reporters show up, 3 reporters get paid and only 1 gets used. And if any of you have a private business, I can tell you that's how you go out of business. And that all gets passed on to the clients. So as under the Department of Consumer Affairs, we're trying to sort of address what your task is, which is to protect the consumer, and also protect the consumer by making more court reporters available, by not triple booking them or 6 reporters for 1 hearing. Ridiculous. So, I'm not aware of any enforcement that is laid out. We don't think this is a silver bullet. We just think that it should, in the end, reduce the unnecessary duplication of booking. And if anybody has any additional questions, I would be happy to try to answer those for you.
Thank you. Our next request for comment is from Dolores Renee Wood. Dolores, I'm going to send you a request to unmute.
Hello, can you hear me?
Yes.
Okay, I just wanted to say I really support everything that Mary Pierce said. And I work often in the family law courthouse. And what happened multiple times is when I've shown up, I would find out when I got there that the court then decided to offer an official. And so what happened was there were several times where I was told that if there were trials already in progress, that if there wasn't an official court reporter available, then the attorneys had to hire privately. But what would happen is they would hire privately, and then at the last minute, they'd say, oh, we have an official available. And so there were several times I had to bill for my time, and they never used me. They actually had the official show up. And I felt really bad about that. So it really is a problem. And also, if there's fee waivers with some of these clients, then they don't, they will have an official provided. And I'm in Riverside County. And I've also heard the judges say kind of what Mary Pierce did. It's like, it's up to the judges to make these decisions. Like sometimes they won't let a reporter sit there for multiple cases. I've had a judge told me, no, you can't do that. It has to be different reporters. And I don't know where that comes from, but I wanted to let you know that's what I have faced because I asked specifically about that. And that's it.
Thank you. And our next request for comment comes from Cindy Tatchell. And Cindy, I'll send you a request to unmute. You're unmuted. Go ahead.
Good morning. This is Cindy Tischel from Los Angeles. I am an official, and I would like to echo the comments made before me in support of this bill. I would ask the board to support this bill. I've been in the position where I've been an official, and multiple freelancers have shown up in the courtroom to cover multiple jobs, and I think it would be a better use of resources for if we support this bill, and I would encourage the board to support this bill. Thank you.
Thank you. And I do not see any further requests for comment. Shall I close the public comment feature?
Thank you, moderator.
You're welcome.
I wanted to check if we have additional comments from the board. Yes, Ms. Brewer.
I do have a question. So I take it from all the comments, and it is something that's needed, that this is intended to ameliorate the situation where we have multiple reporters showing up during the course of a session. And I'm just wondering, okay, so this is, the attorneys have to provide notice. How does this address the situation of a series of reporters showing up for different attorneys who have motions? Because that's another, you know, if there were an official available, they're going to cover the morning calendar. So if there's some way that we can not only prevent multiple reporters being booked for the same hearing, but for the calendar, I don't know if there's a way to do that.
I think this is the first step at the bite of the
So
apple.
this is intended to be the first step at addressing that.
It's a way that would not be onerous for the attorneys to see if they can do that. Then there may be a
Okay, thank you.
Ms. Burr, Ms. Hunke?
Yeah, I would just say to address Miss Wood, didn't know, I'm surprised that the courts are putting an official, but I'm assuming that you don't know until you get there whether there's going to be an official available. I mean, that's just crazy. That's just, I don't understand why the courts are operating like that, because it seems to exacerbate the issue, the artificial shortage. If now you've got the report, it sounds like the attorneys have to bring a reporter to ensure that they're going to have one for their case, but there's still a chance that an official might be there. It just seems to be muddling things even more. Although I do think that this is a first step in doing what the reporters can do to help the courts and help litigants.
Other board comments? Seeing none, yes, I concur. I think this is a good first step, but it seems like we'll need certainly to do more to address a lot of these other situations. With that, yes, Ms.
Do we need a motion to support,
Yeah, I would
take
make
a
a
position of
motion.
support?
And we have additional public comment, and so it's best if we have a motion on the table so they can also comment on the motion.
So I would move that we offer a position in support of this bill.
Thank you, Ms. Hunke, and thank you, Ms. Brewer. With that, we have a motion on the table. Do we have do we have comments from the board on the motion? Seeing none, we will turn to public comment. I'm seeing no additional public comment in the room. On WebEx, please.
Thank you. This is the moderator. We are open for public comment. If you would like to make a comment on the motion, you may look for the hand icon and click that to raise your hand, and our call-in users can press *3 to raise their hand. Our first request for comment is from Dolores Renee Wood. I'm going to send you that request to unmute. And you're unmuted.
Hi, I'm sorry. I raised my hand before to respond again, and I just wanted to state that in Riverside, there's a form that the attorneys have to have signed to go before the judge to allow us to report. They sign off on it. And what happens is if the attorneys do not submit that in time within the 5 days that they're required to submit it on someone who has a waiver, or that they've had a previous trial where an official reporter would show up to report that hearing, that's how there becomes a conflict. So when an attorney schedules at the last minute, then let's say they only did it like 3 days before or 2 days before a trial or a motion, then what happens is the court already told them they can't have an official court reporter there. So that's why they hire a private. So then when I show up and then I get there, they were already told they had to hire a private. That's how that happens, where then the court says, oh, we have an official court reporter available. That's where the conflict is, when the attorneys don't file the paperwork in time and it's a last minute. That's what's happening. So just to give you an idea of how that happens with the court providing at the last minute an official. Okay, that's it. Thank you.
Thank you. Our next request for comment is from Amy Fatima Costa. I will send you the request to unmute. 1 second. There you go.
Thank
And
you.
go ahead.
Thank you. I'm in support of all of the comments that were made by the public here, and also the board members in support of this motion and moving forward. What I have seen and heard from my former students who are working in freelance and court is there's lack of communication between court reporters and court staff who are tasked with filling those courtrooms. And it feels like without this bill going forward, we have a continuation of the left hand not knowing what the right hand is doing, resulting in loss of resources, fees that could be avoided on the part of clients, attorneys, and their clients. So thank you very much for your action on this.
Thank you. And I do not see any further requests for comment. Shall I close that public comment feature?
Thank you, moderator.
You're welcome.
And thank you so much to our subject matter experts who have weighed in on what they're seeing on the ground in person. Appreciate that. With that, Ms. Bruning, would you take the vote, please?
Yes, thank you. Ms. Brewer?
Aye.
Mr. Dodgenham?
Yeah, approved. Aye.
Thank you. Mr. Manayan?
Aye.
Thank you, Ms. Sarkeesian?
Aye.
Thank you, Ms. Tagare?
Aye.
Thank you. Motion carries.
Thank you, Ms. Bruning. With that, I will turn it back to Ms. Fenner.
The next bill we have before us is AB 742 by Assemblyperson Hawari. This would give priority to applications by descendants of slaves. Since our processing time is typically within 2 days and never more than 1 week, it has little practical impact on the board's actions, if you will. Do you want to discuss or take a position?
I believe we do need to have some discussion on this item. Before I turn it to the board, I'll turn it to Ms. Jopper.
Yes, so legal has a few notes that have come up department-wide regarding this issue. First, the legislative intent here is minimal. It basically just explains what, it's a repeat of what the law would actually be without providing what intent the legislature or what they're attempting to fix. For example, this is supposed to be similar to the military priority. And with the military priority, first there was a federal law, but second, the purpose was to help families to do the transition and so that they didn't lose income because they transferred into California. Here the legislature is not clear as to what problem this is trying to solve or where we're going. We did originally have some concerns with persons enslaved within the United States and exactly what that would mean. They've now changed it to American slaves, which does create a little more confusion in that America isn't the only American. There are the Americas, North and South, which could include, depending upon their intent, a broader range of what we're going for here. Last year, it specified African American slaves, and that created some issues regarding discrimination. Here, it's a little less clear, but there may be constitutional issues regarding discrimination. Currently, very few, perhaps 1 or 2 boards, have where personal information about the identity of the applicant is tied to the application itself. And when that data needs to be collected, race, age, et cetera, that's actually on a separate document that is not included with the application itself. And that may actually include it on the application, which means that staff now has some identity of the applicant. And so that's a concern. Further, we are concerned with the burden of litigation. And so our several boards are requesting that this be a, what is the opposite of support?
Opposition.
Opposition, thank you. I want to say objection, but I knew that was so an opposition unless amended to include that the state must carry the burden of any litigation that rather than the board specific. Many of the boards, knowing that this could potentially go to litigation, either in people objecting, people feeling that they qualified but didn't have their registration escalated or prioritized, any complications regarding expediting or prioritizing this with or in front of or behind a military application. Of course, for this board, the impact is minimal, but that doesn't mean that we couldn't be questioned or sued and how much privacy is going to be weighed and whatnot. So we anticipate that there will be burdens of litigation and the state should carry that instead of board specific. So those are the concerns that we have, that we've noted. And so that was what we'd like to inform the board.
Thank you, Ms. Joffrey. Looking to the board for comments. Yes, Mr. Dodgenham.
My thoughts on this are that given the very limited, I think, first off, the intentions are all in the right place. It sounds like a lot of the mechanics still have to be worked out, but given the very little impact on our board and the fact that all the concerns that were just raised will be issues for boards that are bigger and more bigger staffed and bigger equipped to deal with it. I think our opinion at this point should be neutral and to let it kind of play itself out. Not again, it doesn't really impact us too much, so not one we necessarily need to wade into, in my opinion.
Thank you, Mr. Dodgenham. Mr. Manayan?
I just wanted to agree with Board Member Dodgenham, same position as him.
Thank you, Mr. Manayan. Looking to other board members. Ms. Sunkees?
I don't know if we need an actual motion to take a position of watch.
Correct.
Okay.
Yeah, there's no motion necessary for
Okay.
taking.
That's the position I would agree with. Just watch and see how things shake out.
Thank you, Ms. Sunkees. Any other comments from the board? I'll agree that given the low impact to the board, do not see an important need to take a position. I will note that the bill does have some operative clauses so that particularly the issues around determining who is a slave is determined by another bill, SB 518. And so, and it's only operative if that bill goes into place, and that separate bill does include additional discussion for the Bureau of Descendants of American Slavery. And so I think that ameliorates a lot of the concerns that could have been had around discussions of descendancy, but also around issues around Prop 209. With that, any other comments from the board? Seeing none, we will go to public comment in the room. Okay. Seeing none, we'll go to WebEx, please.
This is the moderator. If anyone would like to make a comment on the bill, you may look for the hand icon. It's typically at the bottom of your WebEx screen, or if you're on a mobile device, it may be behind the 3-dot other options, and our call-in users may press *3 to raise their hand. Are there any comments on this item? I do not see any requests for comment. Shall I close that feature?
Yes, thank you, moderator.
You're welcome.
I'll turn it back to Ms. Leonard.
Thank you, Chair Tugade. The next bill is AB 882 by Assemblyperson Pappen. This bill would allow electronic recording on a temporary basis whenever a transcript of court proceedings is required in family law, probate, and civil contempt proceedings if specified requirements are met. Does the board wish to take a position or discuss this one?
I would like to open this item for discussion. Ms. Unke?
Yes, I think that this is a good bill that we should support. I go back to what Ms. Fenner said earlier. Historically, we've not, the board has not supported large-scale expansion of electronic recording. This is limited. It applies to specific courts. It has, it's temporary. It has a clear end date, and it is a way to help the courts until they. It's a way to help the courts put a reporter in the seat. Create a record for those litigants who should have a record of their proceedings. So I think that I think it's a smart, a good bill, and we should take a position of support.
Thank you, Ms. Unke. Ms. Brewer?
I would just agree that I think it's a good, for lack of a better term, kind of a stopgap measure for this problem, and it gives the courts a little bit of breathing room. And with the limitations that are included in this bill, I think we should support it.
Thank you, Ms. Brewer. Other comments from the board? And I appreciate those comments. I'll look to listen to our public comment as well on this issue. Do we have public comments in the room?
Hello again, Michelle Caldwell, CCRA. I will tell you that when we first saw this bill, we said, I'm sorry, you want to do what? You want to expand ER? And so after much discussion, we agree with both Robin and Laura's comments about this is really a compromise and a stopgap measure to give the courts time to really take the ownership back of how we got here to begin with. It does force courts to hire. It forces courts to recruit. It does put the onus and the responsibility back on the courts to get reporters back in the seats to benefit our most needy of clientele really in this industry or in this facet of the court. So we, in the end, believe, because it sunsets too, that this will give the breathing room that courts need right now. And we are anxious to work with courts to help them through that process of recruitment and retention and take advantage of the money the legislature has provided to them to do those things. So we are hopeful that the board will support this scary on its face, but really necessary bill. So thank you.
Any additional comment in the room? Seeing none, we'll go to WebEx, please.
This is the moderator. If anyone would like to make a comment on the bill or the position, you may look for the hand icon and click that to raise your hand. Our call-in users may press *3 to raise their hands. We do have a request for comment from Mary Pierce. And Mary, I will send you a request to unmute.
Thank you. I just wanted to say that CalDRA is in full support of this bill as well. And thank you, Michelle Caldwell, for your insightful comments.
Thank you. And our next request for comment is from Cindy Tatchell. Cindy, I'm going to send you a request to unmute.
Good morning, this is Cindy Tatchell. I would like to echo the comments made by Michelle and Mary, and I would encourage the board to support. Thank you.
Thank you. And I do not see any further requests for comment. Shall I close that feature?
Thank you, moderator.
You're welcome.
And again, appreciate that robust discussion. Do we have a motion from the board? Yes, Ms. Brewer.
I move that we take a motion to support this bill, AB 882.
Thank you. And do we have a second on that motion?
I will second it.
Thank you, Ms. Sunkeys. With that, any comments from the board on that motion? Okay, thank you. Do we have public comment in the room on our motion to support AB 882? Seeing none, we'll go to WebEx, please.
This is the moderator. If you have any comment on the board position or the motion, you may look for the hand icon and click that to raise your hand. Call-in users may press *3 to raise their hand. Any additional comments? I do not see any requests for comment. Shall I close that feature?
Thank you, moderator.
You're welcome.
And Ms. Bruning, would you take the vote?
Yes, thank you, Ms. Brewer.
Aye.
Thank you, Mr. Dodgenham.
Aye.
Thank you, Mr. Manayan.
Aye.
Thank you, Ms. Sunkeys.
Aye.
Thank you, Ms. Tagare.
Aye.
Thank you, motion carries.
Thank you, Ms. Bruning. I'll turn it back to you again, Ms. Fenner. Okay, moving right along. Item 5.5 is AB 1170 by Assemblyperson Dixon. This is just a code maintenance bill and doesn't affect the board really at this point. After that, we have AB 1189 by Assemblyperson Lackey. This bill would require the Court Reporters Board to develop standards for and then subsequently license digital recorders and legal transcriptionists. Board staff has been informed by Assemblyperson Lackey's office that this bill will not be moving forward this year. If there's any need for discussion for something that's not happening. Item 5.7 is a spot bill regarding DCA. We just have it on our radar. Item 5.8 is SB 470 by Senator Laird. This one proposes to extend the current Bagley-Keene Open Meeting Act requirements to January 1, 2030. So just so there's no misunderstanding, the exact rules that we're operating on right now would be extended through 2030, January 1 of 2030. Does the board want to take a position or discuss this one? Yes, please, Ms. Hunter. Do we have comments from the board?
Sure. I think we should take a position in support of this bill. I think it's, as we know, it's helpful financially, at the minimum, financially, to have our board meetings at least partially allow a couple members to not have to be in the room. We can still have our quorum. It'd be nice if we could have at least one meeting a year to be completely virtual, but at least this is a step in the right direction, and so I think that we should take advantage of at least this.
Thank you, Ms. Sunkeys. Mr. Dodgenham?
I just want to agree with everything Board Member Sunke said for all the same reasons, financially and convenience-wise. And I wish it was more, but we're happy with this, at least to support this to continue.
Thank you, Mr. Dodgenham. Yes, I will agree both with those cost-saving measures, as well as just appreciating how much public participation we get online and how critical that is to hearing from across the state. I know we have a pretty full room today, but generally, you know, we have leaps and bounds more participation because of our web option. And so definitely agree with anything that that increases public participation and engagement. Ms. Burr?
Just to complete this, yes, I support this. I think we're in a new world, and things are still kind of changing, actually, with the DCA report saying people are going to have to be back on site 4 days a week. But I think this is actually critical to ensuring that we have a quorum, that we don't have problems with meetings, and realistic for cost. I definitely support this.
Thank you, Ms. Brewer. Any other comments from the board? Seeing none, public comments in the room? Seeing none there, we will go to WebEx for public comment, please.
This is the moderator. If anyone would like to make a comment on the bill or the board's position, you may look for the hand icon and click that to raise your hand. And our call-in users may press *3 to raise their hand. Are there any comments on this one? I do not see any requests for comment. Shall I close that public comment feature?
Yes, thank you, moderator.
You're welcome.
And I will look to the board for a motion. Ms. Sumke?
Sure, I'll move that we support this bill.
Okay, great, thank you. Do we have a second?
Second that.
Is that Mr. Manayan?
Yes.
Thank you. Okay. With that, we'll look to public comment in the room. Seeing none, do we have any public comment on WebEx on our motion to support SB 470, Laird?
This is the moderator. If anyone would like to make a comment on the board's position, you may look for the hand icon and click that to raise your hand. Call-in users can press *3 to raise their hands. Any comments on the position? I do not see any requests for comment. Shall I close that feature?
Thank you, moderator.
You're welcome.
With that, Ms. Bruning, would you take the roll call vote?
Yes, thank you. Ms. Brewer?
Aye.
Thank you, Mr. Dodgenham.
Aye.
Thank you, Mr. Manayan.
Aye.
Thank you, Ms. Sunkes.
Aye.
Thank you, Mr. Gade.
Aye.
Thank you, motion carries.
Thank you, Ms. Bruning. We'll turn it back to you again, Ms. Bennett.
Okay, item 5.9 is another spot bill regarding DCA. And then finally, we have SB 861 by Senator Ashby, the chair of the Senate Business Professions and Economic Development Committee. This is informally known as the committee's omnibus bill. So this year, the Court Reporters Board does have a provision in it. As you will recall, last year, the legislature made changes to our passing percentage for the skills exam from 97.5% to 95%. So this particular provision that we're asking for in the omnibus bill would make that same change for school qualifiers. Just as a reminder to the board, the schools do qualifiers that are intended to mimic the state license exam, and so we want to make it as equal as possible. Does the board wish to take a position or discuss this one?
I would like to open up this bill for discussion. Are there any comments from the board? I would like to suggest a support position given our close work with Senator Ashby on this issue. Are there any motions? Yes, Ms. Sankey.
Although I wish this included the rest of the language of that with the universal testing format to go with the 95%, which I think is necessary, I do think that we should support at least this position. So I agree, we should support the bill.
Thank you, Ms. Sankey. Ms. Brewer, did you have a comment?
Yes. Surprise. I echo what Ms. Sunkey said. Disappointment that we can't get our new testing format into this omnibus bill, but it only makes sense to allow the qualifiers to be at 95% since that is our pass percentage for the test. So I support a motion to support.
Thank you, Ms. Brewer. Any other comments from the board? And I will agree that, again, appreciate all of the work of Chair Ashby and the incredible BNP staff for continuing to work with us on all of these issues. With that, did we need a motion, please?
Did they have any other comments?
Unless there are other comments from our board members. Seeing none, do we have that motion, please? Thank you, Ms. Brewer.
I'll move that we take a position of support for SB 861.
Thank you. And do we have a second?
I
Thank you,
second.
Mr. Dodge-Nam. Okay, do we have public comment on this item? Seeing none in the room, we'll turn to WebEx, please.
Thank you. If anyone has a comment on the motion or the position on the bill, you may look for the hand icon and click that to raise your hand, and our call-in users may press *3 to raise their hand. Are there any comments on this item? I do not see any requests for comment. Shall I close that feature?
Thank you, moderator.
You're welcome.
Ms. Bruning, would you take the roll?
Yes, thank you, Ms. Brewer.
Aye.
Thank you, Mr. Dodge-Nam.
Aye.
Thank you, Mr. Manayan.
Aye.
Thank you, Ms. Dunkeys.
Aye.
Thank you, Mr. Gade.
Aye.
Thank you, motion carries.
Thank you, Ms. Bruning. With that, that conclude our legislative items? Yes, Senator. Thank you. All right. With that, we'll move to agenda item 6, regulations, and I will turn it over to Mr. Vaughn.
Thank you. Good morning. The first item, 6.1, disciplinary guidelines. This regulation section concerns disciplinary and denial guidelines, which set forth recommended discipline for violations of the board statutes and regulations. It was last updated through the Office of Administrative Law, OAL, in 1989. In November 2024, the board voted to approve updates, but since then, board staff and legal have re-reviewed and found that it needed substantive updates, such as including provisions related to license denial throughout the entire document, certain penalties on the penalty guidelines for the violations table in the document, and we added other non-substantive grammatical edits as well. Edits are highlighted in the meeting materials. Staff recommends for this item that the board review and approve the draft regulatory language and instruct staff to proceed with the rulemaking process. Sample motion is in the meeting materials on page 43 of the most recent revised PDF.
Thank you, Mr. Vaughn. Ms. Brewer.
So I did review, as I'm sure we all did, the changes, and I just note one thing, because it looks like what's happening is the language is being made more consistent throughout, and the things that are rephrased are being consistently rephrased throughout the document. And I did note on page 63 of our packet that number 2, rehabilitation program, it says respondent shall within 30 calendar days, blah, blah, blah. And in the other places, it started with the within X calendar days, that language, and then respondent shall. Now, I did not go back, once I noted that, I did not go back and check each instance again, but I know that with most of the places up to that point, it started with the within X number of calendar days. So I just bring that up for people who have made these decisions to consider.
Okay, so that's just from a suggestion from Betsy Figueroa when she was drafting the initial statement of reasons, which is justifying every regulatory change we're doing. And this is non-substantive, so it's just a structural change in the sentence. So it's mostly stylistic, and that doesn't need board approval. But we do appreciate you taking notice of that.
Can I just follow up? If you take a look at number 13 on page 61, notify employees, that's an example of what I'm talking about, where it's in the other form. So I don't care. It's non-substantive. I just, I have an eye for all these nitpicky little things.
Always appreciated, Ms. Brewer.
We love you.
Well,
Any,
that one is substantive, actually, because that wasn't part of the condition before. So that's why
Okay.
it's important to know that one. So thank you for.
Thank you, Ms. Brewer. Any other comments from the board? Okay, seeing none, do we have a motion?
okay.
Yes, Ms. Brewer.
Nobody else is jumping forward. I move that the board rescind its previous November 15, 2024 motion and approve the newly proposed regulatory text and changes to CCR Section 2472 as approved in the materials, and direct staff to submit all approved text to the Director of the Department of Consumer Affairs and the Business, Consumer Services, and Housing Agency for review. If no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for hearing if requested. If no adverse comments are received during the 45-day comment period and no hearing is requested, authorize the executive officer to take all steps necessary to complete the rulemaking and adopt the proposed regulations for Section 2472 as noticed, with the authority to make any technical or non-substantive changes.
Thank you, Ms. Brewer. And just to confirm with our legal counsel, do we need to update that motion to include Ms. Brewer's substantive amendment? Okay, great. Perfect. Do we have a second?
A second.
Okay, great. Thank you, Ms. Sunke. With that, Ms. Redding, would you take the roll? Oh, sorry, public comment. Seeing none in the room, we'll turn to WebEx, please.
This is the moderator. If anyone would like to make a comment on the motion, you may look for the hand icon and click that to raise your hand, or our call-in users may press *3 to raise their hand. Each speaker will have 3 minutes with a 30-second warning. Are there any comments on the motion? I do not see any requests for comment. Shall I close that feature?
Thank you, moderator.
You're welcome.
Back to you, Ms. Brennan.
Thank you, Mr. Gotti. Okay, Ms. Brewer.
Aye.
Thank you, Mr. Dodgenham.
Aye.
Thank you, Mr. Manayan. Thank you, Ms. Sunke.
Aye.
Thank you, Mr. Gotti.
Aye.
Thank you, motion carries.
Thank you. And we will now move to our second regulatory item, that is 6.2, and we'll turn it back to Mr. Vaughn.
Thank you. This concerns the transcript reimbursement fund application and applicant privacy. Court Reporter Board administers the transcript reimbursement fund, TRF, which provides transcript reimbursement costs to indigent litigants in civil matters. This proposed regulatory language states requirements on a TRF application. Section A is for litigants who are representing themselves. Section D is for those who are representing indigent litigants pro bono. Section C states that certain information will be considered personal information pursuant to the Information Practices Act of 1977 and shall not be subject to public disclosure. Staff recommends the board review and approve the draft regulatory language and instructs staff to proceed with the rulemaking process. Sample motion is in the materials on page 44 of the most recent revised PDF.
Thank you, Mr. Vaughn. Do we have any comments from the board? Or a motion?
I would move that the board approved the proposed regulatory text for CCR Section 2410, direct staff to submit the text to the Director of the Department of Consumer Affairs and the Business, Consumer Services, and Housing Agency for review. And if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for a hearing if requested. If no adverse comments are received during the 45-day comment period and no hearing is requested, authorize the executive officer to take all steps necessary to complete the rulemaking and adopt the proposed regulations at Section 2410 as noticed, with the authority to make any technical or non-substantive changes.
Thank you, Ms. Sunkey. Do we have a second?
I'll second that.
Coming from, is that Mr. Manayan?
Yes.
Thank you. With that, do we have public comment on this measure? Seeing none in the room, could we turn to WebEx, please?
This is the moderator. If anyone would like to make a comment on the motion or the issue, you may look for the hand icon and click that to raise your hand. Our call-in users may press *3 to raise their hands. Instructions are on the screen. Are there any comments on the motion or the issue? I do not see any requests for comment. Shall I close that feature?
Yes, thank you, moderator. Ms.
You're
Bruning?
welcome.
Thank you, Ms. Brewer.
Aye.
Thank you, Mr. Dodgenham.
But that was muted. Aye.
Thank you, Mr. Benayan.
Aye.
Thank you, Ms. Sankey.
Aye.
Thank you, Mr. Gade.
Aye.
Thank you, motion carries.
Thank you, Ms. Bruning. And I believe that concludes agenda item 6. Correct? Okay. With that, I am going to turn us to a brief break. We will take 15 minutes. We'll be back at 11:15, actually. Okay.
Okay, they're ready.
Yep. We are back in the room. I will turn to Ms. Bruning to please take roll again.
Thank you. Ms. Sunkeys?
Present.
Ms. Brewer?
Present.
Mr. Dodgenham?
Present.
Thank you, Mr. Manayan.
Present.
Ms. Tagade?
Present.
Quorum reached.
Thank you, Ms. Bruning. We will now continue on with our agenda to item number 7, skills exam grading policies. Ms. Fenner, would you please give us some background on this item?
I'm actually going to turn it right over to Ms. Brewer.
Okay, so we took a look at we being Ms. Sunkeys, Ms. Fenner, and I, took a look at our grading policies. I had previously noted a few things that I thought needed to be updated, particularly considering our new format that we're going to be having. So we have 2 documents. We have the examination grading policies for the skills portion, and we have the punctuation guidelines for the CSR exam, which, by the way, we had a couple of meetings, and I just really want to thank Ms. Sunkeys and Ms. Fenner for all their work on this. I mean, this and the next thing that we're going to talk about, I believe, which is the skills exam. So I would like to make a few little amendments to the exam grading policies before we move that or open it up for comment. And that is on the first page, the first line underneath the title. Please note tests submitted with all, I would like to change the word capitals to uppercase. All uppercase or all lowercase will not be graded. And so then on page 76, towards the bottom, compound words, and this is just to make this consistent with the other items that are outlined as errors. Compound words, each compound word written as 2 words and vice versa, and please add the language, is counted as 1 error. And then on the next page, page 77, if you drop down 1, 2, 3, 4, 5, 6 paragraphs, the paragraph that starts open parentheses, gender, close parentheses, the last 3 words of the first line there, and is indicated, and then continuing on to the next line with a check mark over the word, that phrase should be deleted, and is indicated with a check mark over the word deleted. And then the bottom of that page, 77, is missing a close. Oh no, never mind. That's my error. I didn't turn the page. So that's it for the changes that I would propose. Now, does this, let me just ask you, Ms. Fenner, does this include a report on our progress on the skills exams, or is it only the grading policies?
It was just the grading policies, but I think it would be a good spot if you wanted to also update them on where we are with the test.
Okay, so we have met and people have been hard at work, very hard at work on the new skills tests. And that, once again, I would like to really just my sincere and thanks and appreciation to Ms. Sunkeys and Ms. Fenner for their really hard work. I think Robin and I both sighed when we realized that we had not yet escaped more test writing. Oh my gosh, I thought I was never going to write another test. But we've been not only writing, but writing the lion's share, the 3 of us. And then also we've had people who have joined our task force, members of the public who have joined our task force and written tests. And I would really like to extend my sincere gratitude to Holly Moose, who has been regularly churning out tests. And we had Heather Gonzalez, and I don't know, Heather was impacted, her family, and I don't know if she was directly by the fires in Los Angeles. So that kind of interrupted her ability to participate as much as she would have otherwise. Renee Wood, I know Renee handed in at least one skills test. Michelle Caldwell, who's in the room with us, had committed to a test, and I think we got a test, at least one from Andrea Chavez. So we've had a lot of contributions. Apologies if I've overlooked anybody. It's a lot of work. I mean, just writing one test is a lot of work. And we three have done a lot more than one each. So that's where we stand on that, and so it'll be an ongoing process to continue filling out that test bank. But we've made, I mean, in just the 4 months, I guess 6 months since our last meeting, we've made huge progress on getting tests. So I think that's it.
Ms. Brewer, Ms. Unke?
Yes, I actually want to go back to the grading, the punctuation, the grading policies, and just say Ms. Brewer did the vast majority of the work on this, and so her attention to her skill of attention to detail was highlighted on, was put to good use on this, and I know I speak for Ms. Fenner when I say we appreciate it. And I said earlier, you know, we love you. Well, we love and appreciate you, Cora. So, and yes, the skills, writing the skills test is truly a labor of love. I keep telling myself that. It's a labor of love every time I do another test. Anyway, that's it.
Other comments from our board members? Yes, Mr. Dodgenham.
I just want to reiterate again, as Ms. Sunke did, Ms. Fenner thanked everyone else, but didn't, you know, obviously recognize herself. Thank you for filling in that omission, Ms. Sunke, but thank you to all of you, Ms. Fenner, Ms. Sunke, Ms. Brewer, and all of the public members, Holly Luce, Heather Gonzalez, Renee Wood, Michelle Caldwell, Andrea Chavez. We couldn't get this done without you. This is such critical work for the board, and so grateful for all of it. It looks fantastic, and I'm in favor of approving the new proposed grading policies. Thank you.
Thank you, Mr. Dodgenham. Was that a motion, Mr. Dodgenham?
I was going to let more comments go through, but I think it's going to be pretty unanimous, so I will go ahead and presumptively I move that the board approve as amended the proposed examination grading policies, including punctuation guidelines.
I'll second that.
Thank you. Thank you, Mr. Manayan, with the second. Do we have public comments in the room? Seeing none. Do we have public comment on WebEx?
This is the moderator. If anyone would like to make a comment on the motion or the issue, you may look for the hand icon and click that to raise your hand. Our call-in users can press *3 to raise your hand, and there are instructions on the screen. Would anyone like to make a comment on the motion or the issue? We do have a request for comment from Amy Fatima Costa. I'll send you a request to unmute. Anna, sorry. Go ahead.
Thank you for that. And I appreciate everyone's work on this. I will pass it along to my fellow instructors who I do not teach skills or teach people how to capture the record. I am one of the academic instructors, and I teach them about codes and procedures and how to prepare for the CSR exam review. review. I mean, sorry, CSR exam. So your work on this and clarity, I will share this with my students, for those who are preparing for the written exams, and with my fellow teachers at West Valley College. Thank you all for all your work.
Thank you. We do have a comment request from Mary Pierce. Mary, I will send you the request to unmute.
Thank you. And first, I will recognize a comment about Laura Brewer's attention to detail. It is, dare I say, nearly unparalleled and very much appreciated. Incredibly important work. And I want to thank everybody who participated in the test writing. Again, that is very painstaking work. And these tests are how one gains a license. So the fact that they are being, I know nearly everybody that you named on a personal level, and these are some really talented, skilled, dedicated professionals. And I want to thank each and every one of them that have already been named, so I won't do that again. But that is such important work, and mostly goes unnoticed. So I want to thank you all for recognizing the people that have made these important contributions today, because I certainly appreciate that work. Thank you.
Thank you. And I do not see any further requests for comment. Shall I close that feature?
Yes, thank you, moderator.
You're welcome.
And, you know, I will echo my thanks as well to Ms. Brewer for, as always, that incredible attention to detail, Ms. Sangiza and Ms. Fenner, along with all of our volunteers for that task force. Just incredible work, so thank you. Ms. Bruning, would you take the roll call vote, please?
Yes, thank you, Ms. Brewer.
Aye.
Thank you, Mr. Dodgenham.
Aye.
Thank you, Mr. Manayan.
Aye.
Thank you, Ms. Sunkeys.
Aye.
Thank you, Mr. Gade.
Aye.
Thank you, motion carries.
Thank you, Ms. Bruning. On to our next agenda item, number 8, the skills exam reciprocity with the RPR. For this update, we have Amy Welch-Gandy here from our sister agency within DCA, the Office of Professional Examination Services, to update us on the status of their analysis.
Hi, good morning. We are here today from the Office of Professional Examination Services, also known as OPES. My name is Amy Welch-Gandy, and I'm a supervising test developer, and with me is Dr. Heidi Linzer, the OPES chief. OPES is an office under the Department of Consumer Affairs, and we're responsible for developing and reviewing examinations for the various boards and bureaus under DCA. Our office currently develops the board's English and professional practice examinations. We're here to provide an update on the review of the occupational analysis for the National Court Reporters Association's Registered Professional Reporter Skills Test. This review was conducted as a follow-up to the NCRA RPR program review that was completed in 2021. At the time of that review, an occupational analysis had not been completed by NCRA for the skills test portion of the RPR examination program. An occupational analysis is a detailed study of a profession to define the knowledge and skills required for competent practice. In September 2024, NCRA completed the occupational analysis for the RPR skills test. And in February 2025, the board contracted with our office to review the results of the occupational analysis. In March 2025, OPES worked with a group of subject matter experts, or SMEs, to link the California Dictation Examination Outline with the RPR Skills Test Outline. Together, the SMEs and OPES determined that the RPR Skills Test Outline fully covers the tasks and knowledge areas identified in the California Dictation Examination Outline. OPES also found that the methodology used by NCRA to conduct the analysis meets professional standards. Based on these findings, OPES supports the board's consideration of the NCRA RPR skills test as an option to meet licensure requirements for California court reporters. We have prepared a memo summarizing these results, which has been sent to the board's executive officer, Ms. Fenner, and we would be happy to answer questions that you may have at this time.
Thank you. Seeing a comment from Ms. Sunkes.
Yes, I'm very glad to see you both. Thank you for being here. Thank you for your report. I'm very happy with that we've gotten to this point. I was involved in a task force in 2020 when I first got on the board working on this. And so to see it come to, and I can say, it was easy for me to say the RPR is a great test of entry-level skill, but without the analysis by your department, by your that was necessary for us to move forward as a board. So I am very supportive of it and happy we're here. And how can we get this adopted in regulation or statute, or what is it that we can do? So,
Ms. Brewer, did you have?
I just want to thank you as well. I mean, your work is meaningful to the consumers of California, not only because we need to have competency and we need to make sure our testing is robust, but because people are just screaming crazy for court reporters right now. And we are trying our hardest to do everything that we can to get competent people out there. And this is a fabulous, fantastic step. And I say hallelujah. Thank you very much.
And I left that out. Thank you. Thank you very much for all your work and effort.
So, and ditto, how do we get this into language as soon as possible? Maybe the omnibus bill, maybe, I mean, what's our next step?
Any other comments from the board? And I'll turn to both Ms. Fenner and our legal counsel, but my understanding is that in order to move a motion forward, we could direct staff to take necessary actions to accomplish a legislative. Oh,
Yeah,
sorry about that.
That did not require a motion.
Perfect, okay. With that, do we have other comments from our board? Okay, seeing none. Do we have public comment in the room?
Can I just speak from here?
Oh, sure. Actually, if you wouldn't mind coming a little closer just so that we can get you on mic.
Okay.
Thank you. I'm Michelle Caldwell, CCRA. I just want to say how happy I am to hear this discussion. And I won't say it's about time because that sounds rude, but it's about time. This is fantastic. So I'm anxious about the next steps forward. So thank you.
Thank you.
Seeing no additional public comment in the room, we'll turn to WebEx, please.
This is the moderator. If anyone would like to make a comment on the item, you may look for the hand icon and click that to raise your hand. And our call-in users may press *3 to raise your hand. If you would like to make a comment, you'll have 3 minutes with a 30-second warning. Is there any comment on the issue? We do have a request from Ana Fatima Costa. I'll send you the request to unmute. Go ahead.
Thank you. I am very excited about this news and thank everyone who worked on this. to be able to have the reciprocity with the RPR exam. And point of clarification, I know that this is comment only, you don't answer questions, but is this going to be similar to what the board agreed to do with the NVRA exams, in particular the Certified Verbatim Reporter exam as of January of this year, where CSR candidates who had passed all 4 legs of the CVR or the CVRS for Steno machine did not have to take the California CSR skills exam, but they do still need to take both written exams. So I can wait for a response or contact Yvonne, Ms. Fenner directly. Thank you very much, everyone.
Thank you.
I can quickly confirm that that is the case.
Thank you, Ms. Fenner. Seeing other public comment on WebEx?
I do not see any other requests for comment. Shall I close that public comment feature?
Thank you, moderator.
You're welcome.
And again, appreciate all of the work from Ms. Welch-Gandy and Dr. Linser and all of the OPS staff who have contributed. Again, really exciting to be able to move forward with this. It appears that we have a consensus from our board. And so I believe we, as legal counsel noted, we do not need a motion, but I would like to direct Ms. Fenner to move forward with this initiative with the approval of the board. Thank you. Okay, thank you, Ms. Fenner. And again, so exciting after all of this work. With that, we will move to agenda item number 9, the court reporter workforce development and pipeline. Ms. Fenner, would you share with the board the enrollment and testing statistics you've gathered?
To set the stage for the board's discussion, I want to share some informal enrollment statistics from the schools. So I typically am invited to the RAPS meetings where they do share informally their enrollment statistics. And so I went back and took a look at my notes. And since 2017, the overall enrollment, I didn't compare school by school, but the overall enrollment at schools has increased 286% since 2017. Most, if not all, of the Court Reporter Board recognized schools have opened voice writing programs, which is encouraging as our exam stats show that voice writers have been driving the pass rate up since we began licensing them at the end of 2022. The number of first-time test takers has increased 100% since 2021. Just switching gears slightly, the board will remember that Assemblyperson Callrow from Assembly Judiciary Committee had reached out to the board to offer assistance with training court reporters, perhaps meeting with the Chancellor's office. So before we rush to open new schools, I reached out to our existing schools to ask them what they may need to increase their success, help their program. Of course, many of the suggestions included grants for things like paying graders. They suggested creating a study guide for the English and professional practice tests, also grants for creating new dictation material. One of the other things that they mentioned was also help with maybe securing waivers for credentialing so that it would make it easier for them to recruit teachers. Sometimes they have to be hired as a teacher, but really they're just reading dictation material. They're just readers. I don't want to say just readers, it is a skill, but they would still have to go through the full credentialing process. So with that background, Madam Chair, I turn it back to you for further discussion.
Thank you, Ms. Fenner. And I will take my privilege as chair to kind of set the beginning of this conversation. I think it's no secret that we are currently in a challenging budget situation in this year, last year, the next couple of years, in terms of both the state budget, among other economic issues. But I'm really encouraged by that suggestion around waiving requirements for teacher credentialing. I know in my personal professional experience, the nursing board has had a similar exemption for their teachers, given similar situations with shortages and needing to address that need for teachers. And so I would love to see the board move forward with that issue in particular. I see other comments from our board. Thank you.
I think that is a great idea. I know from personal experience, I have a close friend and colleague who is a teacher at one of the court reporting schools, and that is an issue that they face all the time to be able to recruit teachers, is the whole issue with credentialing. So I think it's something we should definitely pursue. I don't know how that's done, but smarter people than me are sitting at this table, and let's do it. Whatever we can do to help, for sure.
Other comments from our board? Seeing none, I believe this is also a scenario where if we have consensus, we may direct our executive officers.
I can do some research into what that waiver might look like and what we can do with that. Do you want public comment on that?
Yes, let's take public comment on this particular suggestion. Do we have any in the room? Seeing none, do we have any public comment on WebEx? And this is again pertaining to.
Yes, pertaining
I'll just,
to.
And pertaining to waivers for teacher credentialing for our court reporter schools.
Wonderful.
Thank you,
All right,
Father.
so we've opened up the WebEx public comment feature. If anyone would like to make a comment, you can raise your hand by clicking on the hand icon, and our call-in users can press *3 to raise their hands. We do have a comment from Mary Pierce. Mary, I'm sending you a request to unmute.
Thank you. I would like to say thank you so much for the suggested waiver for credentialing. I think that's a superb idea. And and to echo Michelle Caldwell, I don't want to be rude by saying it's about time, but the shortage of teachers has really only been an issue for a year or two now since the waiting list came in. I would think that someone who has been a court reporter could at the very least just, maybe take one class about how to be a teacher. And maybe someone like Anna Fatima Costa, who is so engaged, could prepare something that would assist them. But I do know of retired court reporters who wanted to teach and were denied that because of credentialing. And they were retired from one field. They didn't want to go get a college degree so that they could teach for a short period of time. And I understand there may be a window like you can teach up to a year or two, but you're just going to be hitting your stride at that point. I think this is an excellent idea. And as an individual, and I think I might even be able to speak a little for DRA. Yes, please. Thank you.
And I do not see any further requests for comment. Shall I close the public comment feature?
Thank you, moderator.
You're welcome.
Ms. Sunke?
Yeah, I do have one other comment. I was just excited. I was just revisiting the stats that Ms. Fenner stated earlier about since 2017, overall enrollment in the schools is up 286%. That's astounding. And as well as the number of test takers for the CSR up 100%. I'm so pleased, and that should be, I know that it was and it's being driven by the addition of the voice writers. And I just want to say there was quite a learning curve to get, and it started before I got on the board. The board started this work before I was on the board, the end of 2019. And so it's been going on for years, but it's very exciting to see the fruits of the board's labor, and see the positive, upbeat for the profession and for the consumers of California as a result. So just wanted to highlight that.
Thank you, Ms. Sanchez. Other comments from the board? Sure.
Well, I'll just echo all of that. I don't want to just, repeat what other people have said over and over and over, but it's really exciting to see all these things coming to fruition. And just to have that need for more teachers, I mean, that speaks volumes. It's wonderful. And I will say that personally, I had tried a while ago, maybe 10 years ago, to get on as a teacher part-time with West Valley, and was prohibited because I didn't have a teaching credential. Couldn't do it. So it's really necessary.
Thank you. Yes, and again, yeah, thank you for all of those comments, both from our board and from our subject matter experts. I believe we need to take one more round of public comment regarding this agenda item. That's agenda item 9. But before I do that, I will again, not to repeat it over again, but just to underline again those incredible increases in statistics. Really encouraging. I think really now that we are several years in, I think it's fair to say that we're seeing this trend moving forward. And so again, really appreciate the work of our board staff in making this happen. With that, do we have public comment in the room on agenda item 9? Seeing none, do we have public comment on agenda item 9 on WebEx?
This is the moderator. If anyone would like to make a comment, you may look for the hand icon and click that to raise your hand. And if our call-in users would like to raise their hand, you can press *3 to do that. We do have a request from Ana Fatima Costa. I'm sending you your request to unmute.
Thank you. Are you able to hear me now?
Yes.
Okay, great. Thank you to my colleague and friend, Mary Pierce, for her shout out. But I do want to say to anyone who's listening to this here live and later in the recording, Laura Brewer, oh my God, you would be an amazing teacher. And I want to, stand on what Mary Pierce and Robin Sunkey said. Attention to detail, experts, and you would be an amazing teacher. So come on back to West Valley and try it again. When I was invited to be a teacher, I did not think that I was qualified in any way. I had 44 years as a retired reporter and in various roles and court reporting. And our department chair, Maggie Ortiz, just asked me, do you have an AA? And I happened to have gotten my AA. And she said, you qualify. So anyone who does not have advanced degrees, who has simply an AA, can apply. So anybody out there hearing me and you really want to do this, go for it. We need you. Thank you all.
Thank you. And
Um,
I do not see any further requests for comment. Shall I close that feature?
Thank you, moderator.
You're welcome.
Okay, and I believe we will now move on to agenda item 10, Best Practice Pointers Task Force. Again, the Best Practice Pointers Task Force has been busy, hard at work as always, and so I will turn it to Ms. Brewer to provide an update.
Okay. So since our last board meeting, the Best Practice Pointers Task Force had 2 more meetings, one in January 16, 2025. And in that context, I would like to just make that amendment to the brief summary in our packets under 5. The Best Practice Pointers Task Force met on January 16, 2025 and February 12, 2025. And we had fabulous participation once again from my co-chair, Robin Sunkeys, and staff, Ms. Fenner. And I think that Ms. Bruning might have participated in one, but not both of those meetings. We had other task force members from the public licensees, Brooke Ryan and Mary Pierce, who were invaluable, did a lot of work, had great suggestions. Ms. Costa, Anna Fatima Costa, participated in almost every one of our 5 meetings and had really good input. We had other people who called in. I'm sorry I don't have a list of the names in front of me, but we had a lot of input, and it was really helpful. And you know, I read over these again, and I thought, boy, we did a good job. Nothing like patting ourselves on the back, but right, it's a great example of the whole body of people coming up with a better product than any one individual person. You know, we're better than the sum of our parts. So, and thank you to everybody who participated. It's really appreciated, and everybody really put in their full effort. So we have the new best practice pointers before you, 9, 15, 16, 17, and 18, and I won't go through each one unless people have comments or questions about any of them. I will say that I noticed one place. Okay, I'm going to let it go. It's a comma. I had a comma.
That's going to tear your heart, I know. Tell me afterwards.
It's okay. I think it's probably a quote anyway, so there's no changing it. So that's it. Ms. Sunkeys, do you have any comments too, having also carried the laboring oar on this?
Well, no, you carried the laboring oar. I was just helping. I was there and helped organize. But yes, I did. I echo your comments for sure. It was a good group effort.
So, I'm sorry. Just follow up. So, so this is it for now. We feel that we have finished our current work of updating the best practices, and at this point, it will be an ongoing issue for the future. And our executive officer will collect any suggestions that people put forward, any new issues that come up that might be ripe for best practices. Those would be addressed the next time when this is revisited.
Thank you, Ms. Brewer. And again, thank you for all of that attention to detail. We will fix that comment later. And thank you, Ms. Sunkeys, as well. Any other comments from our board? Do we have a motion from the board? Yes, Mr. Dodgenham.
All right, I will go ahead and I will propose that the board approve the best practice partner. I'm sorry, I will propose that this staff recommend that the motion is I approve as amended of best practice pointers 9, 15, 16, 17, and 18.
And I'll second that.
Thank you, Mr. Manayan.
Can we just clarify one point, please?
Mhm.
I didn't hear any actual amendments, so do we need to have approved as amended or just approved?
Approved as amended, right? But I didn't hear any amendments. So.
So approved as presented, correct?
As presented, yes.
Thank you so much.
Thanks for that clarification, Ms. Bruning. With that, do we have public comment in the room?
I'm sorry, was there a second?
Yes, a second from Mr. Manayan. Thank you. Yes, thank you.
Michelle Caldwell, CCRA. I just wanted to thank the board and Anna and Brooke and Mary for the labor of love in this task force. I know it was a lot of extensive conversations and coming to agreement on how things should move forward. And I think this is just a fantastic guide for reporters in the community. And so thank you for the work.
Any additional public comment in the room? Seeing none, do we have public comment on WebEx?
This is the moderator. We've opened a WebEx public comment features. In response to this agenda item, if you'd like to make a comment, you can click on the hand icon. And if you're a calling user and you'd like to comment, you can click on the *3 to make your comment. We do have some requests. So first is Mary Pierce. I'll send you your request to unmute.
Thank you. Again, I want to recognize Laura Brewer and her exemplary leadership of this committee. It was a lot of meetings and a lot of hard work, and she really kind of kept it as well. Yeah, I would also like to thank everyone else that participated, Robin and Dawn and my friend Brooke Ryan. A lot of comments from Anna Fatima Costa that were insightful, but I also wanted to let you know how important this process was. We just had our DRA annual convention last weekend, and we gave a seminar on the updated best practices pointers. It was a full room, and we've already received at least half a dozen requests for some of the PowerPoint slides, because these are such important guidelines for the reporters, and especially for those of us who work alone, which is basically all of us. And it's a different sort of learning process than when I came into the field 43 years ago, when most of us worked for a big agency and had a lot of mentors within that group. These documents are more important than ever, and I thank everybody who participated in the process.
Thank you. And our next comment is from Anna Fatima Costa. I'll send you the request to unmute. Go ahead.
Thank you. I just have to say that having the opportunity to participate in the revision of these best practice pointers was truly an honor. And observing, the discussions that happened were very informative. And I do want to thank all of the task force, Ms. Hunkes and Ms. Brewer for their work, and Mary and Brooke. I learned a great deal, and I shared what I learned with my students. And I want to shout out to all of my students, because the best practice pointers, bless you, are one of the top resources
that I use to prepare my students at West Valley for the professional practice exam. And their questions, when I present these in detail in class, one by one, until there are no more questions, they inspire me when I don't know the answer to investigate and research myself in order to educate myself. So I'm so proud of my students who speak up. And I tell them that speaking up in class, asking questions is a very important part of their future as an officer of the court, tasked with protecting the record, including interrupting whenever its accuracy is in jeopardy. So speaking up in class is an important step in having the courage to do so out there in the field in front of strangers and intimidating lawyers and judges. And they do, and I learned from them. And quite honestly, I did not think that I had it, as I mentioned before, within me to teach.
30 seconds.
The ability to teach. And there's this saying, you teach what you need to learn, and I am certainly doing that. And I thank you all for creating these. I will be sharing them. One final thing is, when can we expect the revised ones to be uploaded to the CRB website? Thank you so much.
Thank you. I do not see any further requests for comment. Shall I close the public comment feature?
Thank you, moderator.
You're welcome.
Ms. Fenner, I just have a quick response for Anna on when they will be available. There are a lot of people involved, so we have to work with publications and design and editing, and they do it. It has to be proofread, it has to be approved by legal. There's quite a process that goes into it. So unfortunately, because there are so many people involved, I don't have a time estimate for you. Thank you, Ms. Fenner. With that, let's keep moving on to.
Call vote, please.
Oh, sorry. Yes, Ms. Bruning.
Thank you. Ms. Brewer?
Aye.
Thank you, Mr. Dodgenham.
Aye.
Thank you, Mr. Minayan.
Aye.
Thank you, Ms. Dunkeys.
Aye.
Thank you, Mr. Gade.
Aye.
Thank you, motion carries.
Thank you, Ms. Bruning. Now let's move on to agenda item number 11, the 2024 to 2028 strategic plan. Ms. Fenner, would you update the board on the strategic plan action plan, please?
Thank you, Chair Tugade. On page 94 of the board meeting materials, you'll find the action plan timeline that shows the action achieved to date toward the strategic plan objective. I wanted to turn it over to Mr. Dodgenham because he's been working on one of our projects with the logo.
Thank you, Ms. Fenner. Just a quick update. As you know, one of our strategic plans is to update our logo to better reflect current technologies and current uses. So I think as we have a steno machine on our current logo, we want to update that to be more relevant and modern. So we had a very productive kickoff call on March 25th of this year. That was the design kickoff call in which we completed a design logo brief where we just had a robust discussion with the design team about whether we want to be modern or traditional, reserved or bold, serious, relaxed, things of that sort to really define what we were looking for. And in the last 2 weeks, we've received back some first round of logo proofs. And these proofs are intended to help guide us for the next round, to be the discussion points. They're all in black and white. They're idea points that can take us in different directions. And we will be reviewing those with the design team on May 13th. next week to share our feedback, to then hopefully go to a second and possibly final round of design proofs. We expect and anticipate that we are on track to be able to present to this board proposed new logos for your approval at our next meeting. Any questions?
Thank you, ma'am. And thank you for all your work on that.
Thank you.
And then I would just open it to the board if they have any questions or comments on the action plan. Ms. Burr?
Yes, I did have a question. So on 1.5, explore the possibility of provisional licensing to promote fully licensed reporters and address the shortage of licensees. Now, I know that was in proposed legislation that was withdrawn or written. It went away. Any provisional licensing that was proposed in a bill that was out there, that went away. And I'm just wondering if that would affect our status, how we mark that. I mean, seems like we're not really pursuing the provisional licensing now because we're getting reciprocity with the RPR. We're going other directions. So do we want or need to do anything with that item? And I would throw that out for comments from the other board members.
Thank you, Ms. Burr. I can maybe address that. I think that what to keep in mind is the strategic plan is actually a living document. And so even though we take the opportunities and the time to get all of the information and we put our best guess at what's going to happen in the next 4 years, sometimes there are big changes. And so we're seeing a lot of the board's efforts come to fruition, especially with the licensing and the reciprocity. So this may have less priority and it may even become moot. I would recommend we just keep it at the bottom of the list and not worry about the artificial dates assigned to it, because perhaps when it comes time for our next strategic plan, we'll say, oh, we never did that, but it turns out we didn't need to.
Okay. Thank you, Ms. Brewer. Other comments from the board? I would like to underline item 1.7, the demographic data used to identify any workforce issues. Again, really exciting to hear our tech modernization project has reached this point. I would love to, again, bring up, I know in the past, with last year's legislation, we had been seeking some additional amendments to ensure that that is clear that the board has the ability to collect demographic data such as race, ethnicity, gender, identity, et cetera. And so would love to direct our executive officer to, again, pursue that along with other legislative work that we're pursuing.
I think that we can do, if we do it on a voluntary basis, which I think most places do, I think that it's just a software issue, a redesigning of our forms. So I think that can be done much more quickly than having to go through the legislative process.
Right. Thank you, Ms. Fenner. Other comments from the board on the strategic plan? Okay, seeing none, again, thank you, Mr. Dodgenham, for all your work on our logo and making us a more inclusive board. With that, do we have public comments in the room? Seeing none, do we have public comments on WebEx?
It's the moderator.
And this
if
is in
anyone...
regard. Thank you, and this is in regards to all of the agenda items 11, so anything on the strategic plan. Thank you.
Exactly. If anyone would like to make a comment on any of the items discussed in the strategic plan, you may look for the hand icon and click that to raise your hand. Call-in users can press *3 to raise their hands. We do have a request for comment from Ana Fatima Costa. I'll send you a request to unmute.
Thank
Go
you.
ahead.
I'm sorry, I was writing a bunch of things down. Did I miss any discussion on action item 1.3? Assess the feasibility of adding one in-person test annually to improve accessibility and inclusivity. And I will take if it's possible to get a response, I will take it offline. Thank you.
Thank you. I do not see any further requests for comment. Shall I close the public comment feature?
Thank you, moderator.
You're welcome.
Ms. Feather, did you want to? Just to quickly address Ms. Costa's comment, we that additional one-person meeting at the last board meeting in November of last year, and in light of our current budget and the success of the online program and statistics, the board is no longer considering that additional one-person in-person test.
Thank you, Ms. Fenner. Do not believe we have a motion required for this agenda item. And so we will push on to agenda item 12, AI generated deposition summaries. Ms. Fenner, would you introduce this agenda item for us?
Sure. At the November meeting, the board clarified that the existing regulation, which is on page 96 of the board materials, did not prohibit AI-generated depo summaries. The board did wish to discuss the topic in greater detail, so it's back on the agenda for further exploration. You may want to check with public comment first on this one to see if they have any input on if there's still an issue.
Thank you, Ms. Fenner. So we'll start with public comment. Do we have any in the room? Starting agenda item 12. Okay, seeing none. Again, we'll turn to WebEx for public comment on agenda item 12, AI generated deposition summaries.
This is the moderator, and we are open for public comment. If you would like to make a comment, you may look for the hand icon at the bottom of your WebEx screen. Our calling users may press *3. Are there any comments? We do have a couple of requests. First is from Ana Fatima Costa. I'll send you a request to unmute. Go ahead.
Thank you. I remember we discussed this at November's meeting. I wasn't present the entire day, but I was confused by 2474A, which stated that the term deposition summary means information dictated by an attorney and reported and or transcribed by the court reporter after the conclusion of a deposition. That makes no sense to me. I don't know of any reporter who would report a deposition summary after a deposition. I'm just curious if is the board going to change that language? That would be, if any reporter did that, that would be a violation of the basic fundamental rule of a reporter to be impartial. And I worked for a litigator, and I have several legal secretary, attorney, and paralegal friends. There's no way that I don't know if any reporter would ever do that. So I'm not clear about what language will be changed. Are you going to eliminate A, 1, 2, 3, 4? Thank you.
Thank you. And our next request for comment is from Mary Pierce. Mary, I'll send you your request to unmute.
Thank you. And part of what I'm about to say, I hope will address a little bit of what Anna had to say. And on the one hand, I agree with her. I wish that nobody were providing these, but as I spoke at the last meeting on this topic, if anyone's going to be allowed to, everyone should be allowed to. And the conclusion from the board discussion, as I recall, was that if platforms, if online platforms are being used to produce these summaries, the court reporter actually isn't participating, and that was sort of the workaround for the language. But I hope, and I may have additional comments after the board revisits this discussion, but my biggest concern is whether agencies are taking appropriate precautions and if they even exist, because any content that is in a deposition that is then uploaded to the cloud, which must be done to produce these summaries, is exposed to hacking, access by nefarious characters, and possible compromise of intellectual property, proprietary information, HIPAA protected information. So I don't know how you can just ban this completely, but I do have concerns about it, but there has to be an equal playing field, and that was why I spoke so strongly about it in the past meeting. But I will definitely be looking forward to the discussion had by the board. Thank you.
Thank you. And I do not see any further requests for comment. Shall I close that public comment period?
Thank you, moderator.
You're welcome.
And so we will turn it back to the board for any comments. Ms. Brewer.
So I feel that there is a need for more information to make a meaningful decision about this. Clearly, the code as it exists now, the 2474, does not apply to what's going on with the AI-generated summaries. So I think it's a completely different animal, and to know whether that completely different animal needs to have any controls or cautions or rules or regulations put around it, on my behalf, or on my part, I would need more information. And the basic information that I would need is I would want to know what learning is being used to train the AI model. Is there any private information or not publicly available information being used to train these models? Or is it just an off-the-shelf thing that anybody can get, this AI model? And if it's the latter, I don't have so much of a concern about privacy. If it's the former and it's using information from other litigation or other clients of the agency, information that's not publicly available, then I would have a serious concern about privacy. So that's number one, the privacy vis-a-vis what learning the AI model is based on. So, and if it's most AI is iterative, so it continues to learn. So I think that's important information to need to know and to consider, to know whether this is a consumer-facing issue for privacy concerns. So that's number one. And then number two, my second issue, which I brought up at the last meeting, is it's kind of twofold. Does everybody in the litigation have equal access, the opportunity to purchase the exact same summary that the first party orders? So if defense attorney A orders an AI summary from the agency, can the plaintiff's attorney or defense attorney B, or the other parties, are they able to get the exact same item? Because I think that bears on our equal delivery of our equal delivery obligation, access to equal delivery. So, and also connected with that, I had another thought about it. course, I'll think about it later.
My apologies.
Well, just if these are fungible, you know, do they change? Is it a different summary depending on who orders it? Is it customized? And if it's customized, depending on whether you're a defendant or defendant A versus defendant B or plaintiff 1 versus plaintiff 2, then that becomes an issue to me because unless it's available to everybody. So it's equal access to all parties to whatever's being delivered to one party. And those are my issues related to this.
Thank you, Ms. Brewer. I appreciate that very succinct summary of a lot of the issues that we discussed last meeting, as well as I think I agree with many of your concerns, particularly the privacy issues for consumers. Mr. Manayan.
I'd just like to echo what my board member Brewer said. I think, you know, AI, the language models that are being used, there's always some level of subjectivity in each of these. Ask it the same question 3 times and it'll generate 3 different responses. So there is no, I want to say, quote unquote, off the shelf learning model or AI model that can, at least from my knowledge, right? I'm not a technical expert, but I'm familiar with it enough and have used these enough, and in a legal context too, to know that you can't rely on them. So whatever we do, I don't think we should prohibit the use of these. But if these AI summaries are going to be generated, then we need to make sure, from a public perspective, protecting the public, that there should be clear notices that these are AI generated summaries, that they may have that they may be subjective, and to not rely on them as official reporting documents, because you just can't, we're not there yet, and I don't know if we ever will be, where at least in the near future, where we can say that these are all quote unquote off the shelf standard without any subjectivity. So whatever we do, from a public protection perspective, we need to keep that in mind.
Thank you, Mr. Manayan. And I would add to that that we also need clear notice to consumers when their data is being used to train these models as well. As Ms. Brewer noted, particularly with private data. Mr. Dodgenam.
I just want to add to what folks said and then make a suggestion. But I think that first off, our initial concern when we looked at this was that it was violating the regulations regarding taking an attorney's dictation. We've confirmed that that is not the case, so it's not relevant under the current regulations, and I hope that clarifies the questions from our public comments from Anna, that the reason this regulation was in here was to show that the current practices do not seem to be violating this regulation. Our other concern was exactly as Ms. Pierce stated, we want to make sure if this is available to the big boxes or whatever we want to call them, that it's available to all, because at the end of the day, our objective here is to have as many court reporters available, and if this is a disadvantage to some, then we might not have enough folks in the profession or motivated to be in, so we will make sure it's equally available to all. So on that one, and the other concerns around privacy, transparent notification that these are AI generated, and the other issues that were brought up, I think we really need to rely on our public here to inform us what issues are occurring, if any. I want to caution us from trying to regulate something that is not an issue, but what we really need help for, and I would encourage at our next meeting that we have some time to get feedback from the public on, are these transcripts working? Are they in fact providing an additional, a great convenience to both parties and giving additional source of income for our court reporters? Or are there issues that are either negatively impacting our consumers or negatively impacting a segment of our court reporters that we need to address? And that until we get that feedback, that we don't take any immediate action. Thank you.
Mr. Dodgenham. Ms. Funke.
Along kind of piggybacking on that, that was my thought too. And I had a question. Has the board received any complaints about these from my other consumer attorney? Okay.
Nothing.
So we've been made aware that it's happening, but until there's a complaint, we don't know. I mean, we're aware of the issues that could occur, but I think that we wouldn't be in a position for the board to do anything unless we were presented with a complaint. I would think. Obviously, I'm thinking out loud. That's just my thought process.
Well, I can say that when we receive a complaint, then we know what the issue is in more detail. So right now,
Thank you for helping me.
We're imagining consumer harm. We're imagining all of the millions of scenarios that could be out there. And because we're good citizens, we want to fix it before it happens. And so I think Mr. Dodgenham's point is well taken. Maybe we just need to watch this closely. I can do some research and see what I can find out on some of Ms. Brewer's questions, but just so that we're informed and we can be ready in case we do need to react.
All right, thank you, Ms. Fenner, for that clarification. I will say, particularly again on those privacy and the notice to consumers issues, I imagine that part of the reason we're not receiving complaints is because consumers are unaware when their data is being used, or they're not receiving notice that that the deposition summary has been AI generated. And so I think to some degree there's some duty to at least have that that consumer protection measure available, because otherwise we will continue to not receive complaints. Other comments from our board? Seeing no other comments, I would smile on a motion to at least clarify those consumer notice issues, just given again that consumers can't raise issues on something that they don't know is happening or that they're not being noticed of.
I'm hearing staff being directed to do the research to find out if that is the case, and then I'll bring that back at the next meeting.
Perfect. Okay. Thank you, Ms. Fenner. Do we have any other conversation, discussion from the board? Okay, seeing none, we will go back to public comment. Do we have any public comment in the room? Again, on agenda item 12. Okay, seeing none, we'll go to WebEx, please.
Just a point of order.
Mr. Dodgenham?
Just a point of order. Do we need to make a motion for that? And if so, are you making that motion, or is it just a suggestion to the staff?
Thank you for that clarification, Mr. Dodgenham. Because we're directing staff to do additional research, no motion is required.
Great, thank you.
Yeah, so again, public comment is on agenda item 12, AI-generated deposition summaries. WebEx, please.
Thank you. This is the moderator. If anyone would like to make a comment, you may click on the hand icon to raise your hand, or you may, or call-in users can press *3. We do have a couple of comments, one from Heather Lynn Gonzalez. Heather Lynn, I'll send you a request to unmute your microphone. You'll have 3 minutes with a 30-second warning. Go ahead.
Hi, are you able to hear me?
Yes.
Perfect. I would, in the interest of knowing that that no action can be taken until someone has complained and the consumer notice, I do think it's important to focus on what was brought up about the disparity in creation of the transcripts, that court reporters are required to provide this in order to remain that neutrality. They have to provide the same thing to both sides. They have to. So I think that's something that is a more immediate issue for court reporters, that the big box firms or the small firms can't be creating tailor-made AI generated, like putting in the parameters that the client has requested, but not offering that to the other side. And I think that does touch on the neutrality issue and the offering the same products to all. Thank you.
Thank you. And our next request for comment is from Mary Pierce. Mary, I'll send you a request to unmute.
Heather Lynn stole my thunder just a little bit, but that's okay. She's a very bright lady. I just would agree, and this also addresses something that Laura Brew brought up. I believe that any certified court reporter, certified shorthand reporter, or registered firm cannot provide a service unless it's a service for hire. Like, I have this audio transcription that, you know, was not a public proceeding, and that's a work for hire. But if this generation of an AI summary comes from a public proceeding, such as a deposition, that all parties must be offered the same services, or you are going to be in violation of 2025 320B. So I think that, and if they want it customized, they should run it themselves, because otherwise you may be disclosing your trial strategy, your case strategy to the other side. Because, you know, I think if anyone doesn't know, you can put in specific prompts. What did the witness say that can help me win the case for the defense? Something such as that. So yeah, if provided to just one party, I believe you'd be in violation of the CCP. Thank you so much.
Thank you. And our next request for comment is from Dolores Renee Wood. Dolores, I'll send you a request to unmute.
Thank you. I'm not sure if this relates to the same thing, because some of the big box companies we have are owned by attorneys, and they also offer litigation support. So they'll do like proofs of service, they'll do legal work. And I'm thinking they could do tailor-made summaries, even though they're also running that court reporting agency or firm. And so when I'm looking at that as opposed to CSR owned firms, I really don't know how we could ever compete with them because they're attorneys. So I just wanted to throw that out there. And that I do think that there should be basically safeguards in place as to not using learning language model AI, but more along the lines of closed platforms that can produce AI summaries so that information is protected. So that's all I have.
Thank you. I do not see any further requests for comment. Shall I close that public comment feature?
Thank you, moderator.
You're welcome.
With that, I believe we'll continue to keep this item on our agenda and on the board's radar. That gets us to agenda item 13, future meeting dates. Ms. Bunny?
We don't have anything ready to vote on. As soon as we do, we'll poll the board members and see what you have available for calendars. If anything comes up urgently legislatively, that may be July. Otherwise, it may be August or September. So I'll just keep you posted. Thank you, Ms. Fenner. Do we have any board comments on this agenda item number 13? Seeing none, do we have public comment on agenda item 13? I'm seeing none in the room. We'll turn to WebEx, please.
This is the moderator. If anyone would like to make a comment on the future meeting dates, you may look for the hand icon and click that to raise your hand, and calling users can press *3 to raise their hand. Any comments on future meetings? I do not see any requests. Shall I close that feature?
Thank you, moderator.
You're welcome.
That is our last agenda item. This brings us to item 14, but we have no business for closed session. So this will conclude the May 9, 2025 board meeting. Thank you, everyone. And thank you again to all of our folks who have stayed on for the meeting.
Thank you, everyone.
Thank you.